Okay, so you've probably seen all these politicians and commentators saying, will the post office be facing manslaughter charges? And indeed, will Paula Vennells be facing manslaughter charges? Well, to cut to the chase, there is actually a route that they could bring manslaughter charges against the post office and indeed Paula Vennells. But my guess is that Paula Vennells is more in trouble for things like perverting the course of justice. So what I thought I'd do is give a quick intro to how they can get that way to bring a manslaughter charge, and also why Miss Vennells may be in trouble. So hopefully this will be quite a quick one, although I don't actually plan these, so it'll probably like be 5 hours. But anyway, what's the route to the post office? We now have a thing called the Corporate Manslaughter and Homicide Act. It's got two titles because it applies in both England and Wales and Scotland. And down here we say manslaughter, and up there they say homicide. But the same rules apply. Why did that come about? It's relatively recent, it's only about 2008. The problem previously with trying to bring manslaughter cases against organisations, things like hospitals or construction companies, things like that, for health and safety breaches, is you had to identify what we called a controlling mind. That was somebody within the company who had made decisions that led to that outcome. And that was often very, very difficult because really you had to just prove manslaughter against an individual, and then the company was vicariously liable. Vicarious liability is where somebody who has oversight of somebody, usually like employer-employee relationship is the common one. They are responsible for anything that person does within the remits of their job. Some very interesting cases on that because what you always argue for an employer, and somebody sues on the back of something one of your employers did, is that they were on a frolic of their own, to use the rather delightful language. So you argue that it's not within the remits of their job. But there's a really interesting one where somebody sued a bus driver for punching. They punched a passenger because they had a row about fare dodging. And what was great there is said, nah, buses are like that. People fare dodge. There's going to be rows about it. It's perfectly foreseeable that your drivers are going to get into punch-ups. So the bus company was actually held liable there. But like I say, it was proving difficult. So they basically copied how we do health and safety prosecutions. Now, in health and safety, to prosecute a company, you just need to show that they had failed to provide a safe system of work. So you looked at the system, not necessarily the individual decisions, because especially in health and safety deaths, a lot of the time it's what we call the Swiss cheese model. So you have loads of slices of Swiss cheese, and you try to put a pencil through them, and unless a load of holes line up, you can't get the pencil through. And the argument is that each of those slices is one possible decision, that the person making that decision might not have realised the impact, but that just allowed one weakening. And if in that chain anybody had done their job properly, just one single person, at least one of those slices wouldn't have a hole that lined up. So that's what they decided to do. So the test now for corporate manslaughter is you just look at the system. You say, overall, is there a system that was running so negligently or so dangerously or so recklessly? Manslaughter is it's a common law offence. This is a statutory version, but the old tests are you just look at the facts. But for what you did or didn't do, would the death have occurred? It really is that simple. So in this particular case, they'll just look at how the post office was run. But how does that get to manslaughter? Well, obviously, a number of the postmasters, they just couldn't cope, and they just ended it, didn't they? So, can somebody be responsible for an act if somebody then goes off and tops themselves? Because the argument is going to be there. It's what we call a novus actus intueniens. I've done this on another video about causation and negligence. But the idea is, well, yes, I did something wrong, but then something came in that wasn't reasonably foreseeable or was out of my control, somebody else is responsible for that. I mean, it can be a third party. Um, like I say, the classic example is if you injure somebody and they are made worse by negligent hospital treatment, negligent hospital treatment is seen as reasonably foreseeable, so you're liable for the additional damage. But if on the way to the hospital some reckless driver totals the ambulance, then that will be an intervening act. What's weird is most of these cases are about squaddies taking people to the infirmary on stretchers and dropping them. I don't know why, but there's a massive string of that. Anybody in the forces, feel free to tell us in the comments if that was a common thing. If it's because of, I'm injured, we've got the stretcher bearers. No, I'm fine, I'll walk. So the argument there will be, was that a foreseeable consequence, and was it as a result of the post office's actions? Now, there have been some cases on this. There's even been an attempt at prosecuting for murder, and that was where she had thrown acid over a guy, and his life, just become unbearable. So he actually went off to Dignitas, and he ended it there. So she was prosecuted both for GBH, for throwing the acid, but also for murder, because they said, had you not done that, then he wouldn't have killed himself. And for murder, the mens rea for murder is an intention to commit serious harm, and obviously throwing acid over somebody proves that intention, with the result that somebody dies as a consequence. With it, it's now got to be within 3 years. If it's more than 3 years, then the Attorney General has to approve of any prosecution. It used to be that you had to die within a year and a day. But the problem there is, as medical treatment got better, we had life support and things, you didn't really want sort of the CPS hanging around your hospital bed on sort of like day 364, sort of, getting ready to flip your switch off. So that's the idea there. So she was prosecuted. Now, she was actually acquitted of the murder. Although the judge gave her a life sentence anyway. Just said it doesn't matter, because judges can always take into account the consequences anyway. They've got quite wide sentencing powers, although they are bound very much by the sentencing guidelines. Obviously, the fact that somebody felt compelled to do that is a massive aggravating factor. But there have been some manslaughter cases where, for example, people have chased people. They've scared them. So that's that's an assault. That is an unlawful act. Chasing after somebody, and people have run into traffic and been run over, or they've jumped over bridges. And in those particular cases, this has happened in a few jurisdictions, people have been held liable for those consequences. So the argument here would be, but for the post office doing this, effectively, the argument you'd make to any jury is say, well, look, it's really simple. If the post office hadn't done everything they did, which was wrong and unlawful, would this person still be alive? And the answer is probably yes. Because it doesn't have to be the sole cause of the death. It has to be what we call a proximate cause. So even if they could argue and say, well, this person had a lot of other problems in their lives and they were depressed anyway, if it was, well, no, your actions were definitely something that, had a result on that, even if there were other factors at play as well, that can get you. So yeah, it wouldn't surprise me if people did try for corporate manslaughter charges here, if only as a test case. What about the Miss Vennells, though? Well, rather strangely, within the corporate manslaughter legislation, you can also find an individual guilty within the same act, and that is where, upon investigation, they are such a sole contributor to the failures in the system that they should be held personally liable. Now, arguably, you might say, well, why not just charge them separately for manslaughter? The reason is it's just for convenience for housekeeping, like arranging trials. What they've said is, no, prosecute everybody together. And also there might be parallel health and safety proceedings, because if you've provided a safety of work that's so intolerable, people end up ending themselves, then that's a health and safety breach as well. And there again, they've said, no, have just one trial dealing with everything because it's more convenient, it's simpler, and also it avoids the embarrassment of inconsistent results across different trials. So theoretically, if they were to say, Paula Vennells, she was, so at the heart of this, and she made certain decisions, then yes, she should be individually liable as well as the post office. I mean, I don't know. I don't know what her role is. She's certainly, it's now turning out that she knew. There's no dispute about this, that seniors at the post office had been warned by Second Sight that they were knowingly prosecuting people where they had valid defences and they weren't providing the evidence to show that defence. I mean, those phone calls with Second Sight are just quite staggering. They were clearly trying to do their job properly. And of course, as soon as they started insisting on being able to do their job properly by having access to stuff they'd been promised, they got sacked. But yeah, I mean, in this next stage of the inquiry, there's some lawyers are going to have some embarrassing questions because these are lawyers who were told, actually, yes, there are problems and you need to disclose this, and they didn't. And they, denied that there was any disclosure. So they're going to be in trouble both with their regulators and with the authorities because this does cross the line into perverting the course of justice. You don't actually have to, cause an injustice, although clearly in these cases they did. You just have to basically do something that might tend to pervert the course of justice. It's a very sort of low threshold. Oh, I've just lost a light. Well, I'll keep talking anyway. So, why has that done that? Oh, yeah, the camera's still there. Ooh, it's spooky. Anyway, I'll wrap up soon because I'm not going to re-edit this because I'm too lazy and I've been a bit poorly. So she might well get done because, perverting the course of justice, it's just a finding of fact. Did you do something that might have the result that somebody does not get a fair trial? Or, or indeed somebody is prosecuted when they shouldn't be prosecuted. I mean, that's a very common one, when people make false accusations, they get done for perverting the course of justice. So there you go. As always, hope you found that vaguely useful, vaguely interesting. And like I say, so, while some of these politicians maybe are just doing it for column inches, there is actually a realistic prospect that this could happen. Also, is it safe to talk about this? Well, technically, there is the risk of, prejudicing a fair trial, contempt of court. But there are no ongoing proceedings at the moment. And I don't think it's arguable that proceedings are even contemplated, because the police are saying we're going to sit back and see what the result of the inquiry is. So unless and until they pull their finger out and start doing something, I think it's fair for everybody to comment on this. So there you go. If you did like this, blah, 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 please consider liking, sharing, subscribing, all that sort of thing.